How to prove undue influence. Undue influence is the legal term for someone exerting so much pressure on another that it overcomes that person's free will to execute contracts or make transactions. If you believe you or someone you care about was improperly convinced to execute a legal document, such as a contract or a will, there is something you can do about it. This article discusses what undue influence is and how to properly plead and prove it in a court of law. Understanding undue influence. Know the definition of undue influence. Undue influence can occur anytime someone applies improper pressure on another to create a legally binding obligation that is not in the maker's best interest. The obligation becomes voidable, meaning it can be set aside by a court, if undue influence is proven. Undue influence goes beyond flattery and general pushiness and may include threats and harassment. There are generally 4 elements, things you have to prove, to make a claim of undue influence. Check your statutes and case law for jurisdictional variations. They are: a weakened or vulnerable state of the victim, the opportunity for the other person to take advantage of that state, acts by the other party in taking advantage of the weakened state, an unusual or suspicious transaction. Determine the victim was in a weakened state. The law assumes that people of normal mental and physical health can say no. Therefore, if a normal person decides to sell or give away items, the law does not protect them from themselves. A person considered to be in a weakened state is different, however. That person is assumed to be susceptible to the less scrupulous because of their increased vulnerability. Some things that indicate a vulnerability include mental or physical illness, recent physical or mental trauma, advanced age. Show the other party had opportunity. There must be an opportunity for the other person to take advantage of the victim's weakened state. This is usually satisfied if there is a special relationship between the victim and the other person. Many jurisdictions presume that undue influence occurred if certain special relationships exist. Consult an attorney or review your statutes and case law to see which relationships qualify in your jurisdiction. Special relationships can include trusted friends, attorney-client, doctor-patient, family members, caregiver-patient. Display that the other party took that opportunity. You also must prove that the other party actually took advantage of the special relationship and the victim's weakened state. This can be done by showing that the victim likely would not have made the obligation had the other person not exerted the influence. Some examples of this would be a terminally ill person changing the will at the request of the other person, an elderly person making an investment in at the request of the other person, an injured person giving away their belongings at the request of the other person. Isolate the unusual or suspicious transaction. Often, even in a confidential or special relationship, the transaction or obligation is in the best interest of the vulnerable person. Therefore, for undue influence to apply, the transaction must be unusual for that person or situation or suspicious in some other way. Suspect transactions may include giving away or selling long-term family heirlooms, changing a will from long-term, cherished relatives to a person only known for a short period of time, investing in highly risky ventures by someone who is normally risk-averse. Defeat any defenses. Finally, once you raise the charge of undue influence, the other party has the right to present any defenses. If a defense is successful, the transaction or obligation cannot be set aside and must be honored. The 2 most prominent defenses are: the victim received qualified, independent advice, such as from a third-party attorney or other professional. This indicates that the victim was fully informed and aware of the nature of the transaction and made a conscious choice to go through with the transaction in spite of the issues. The transaction was fair to the victim. If the transaction was fair to the victim, even if it is beneficial to the other person, then the other person is not seen as having been the result of unfair advantage.